Question 1. A notary public's commission in New York is for a term of A. 2 years. B. 4 years. C. 5 years. D. 10 years. Answer: B. 4 years. The appointment as a notary public in New York State is valid for a 4-year term. This term is set by state law and begins on the date the commission is issued by the Secretary of State. Notaries must keep track of their commission expiration date to ensure they apply for reappointment in a timely manner and avoid performing invalid notarial acts. A helpful tip is to set a calendar reminder several months before your 4-year commission expires to begin the renewal process. Question 2. If a notary public in New York moves their business and residence to a different county within the state, they must A. Resign their commission and reapply in the new county. B. Only notify the county clerk of their new county of residence. C. File a change of address form with the Department of State. D. Obtain a new seal with the new county name. Answer: C. File a change of address form with the Department of State. New York law requires a notary who moves within the state to file a change of name/address form with the Secretary of State's Division of Licensing Services. This ensures the state's official records are accurate and that the notary's commission remains in good standing. While the notary can also file their signature in the new county clerk's office, the primary legal requirement is notifying the Department of State. Always remember to update the state first whenever your personal or business information changes. Question 3. A New York notary is asked to notarize a document for a close family member. Which of the following statements is true? A. Notarizing for family members is strictly prohibited by law. B. Notarizing for a spouse is allowed, but not for other relatives. C. A notary may notarize for a relative, provided the notary has no beneficial interest in the transaction. D. A notary may only notarize for a relative if a second, non-related witness is present. Answer: C. A notary may notarize for a relative, provided the notary has no beneficial interest in the transaction. New York law does not explicitly forbid notarizing for relatives, but it prohibits a notary from acting in any transaction where they have a direct financial or beneficial interest. For example, a notary could notarize a car title for their sibling, but could not notarize a deed that grants the notary partial ownership of a property. The key is avoiding a conflict of interest that could challenge the notary's impartiality. To avoid any appearance of impropriety, it is often best practice to refer a family member to another notary for important financial or legal documents. Question 4. The venue section of a notarial certificate, which typically reads State of New York, County of _____________________________________________________________________ indicates A. The county where the signer resides. B. The county where the notary's commission is filed. C. The county where the notarial act is taking place. D. The county where the document will be recorded. Answer: C. The county where the notarial act is taking place. The venue establishes the geographical location where the notarization occurred, which is a critical component of the notarial certificate. It confirms that the notary was acting within their authorized jurisdiction at the time the signer appeared before them. For instance, if a notary commissioned in Kings County performs a notarization for a signer while they are both physically in Queens, the venue on the certificate must state, County of Queens. Always fill in the venue with the county where you and the signer are physically located at the moment of the notarization. Question 5. What is the maximum fee a New York notary public can charge for administering an oath or affirmation? A. $1. B. $2. C. $5. D. A reasonable fee agreed upon with the signer. Answer: B. $2. New York state law sets specific maximum fees that a notary can charge for their services, and the fee for administering an oath or affirmation is capped at $2. This fee also applies to taking an affidavit or an acknowledgment. Charging more than the statutorily allowed amount is considered official misconduct and can lead to penalties. It's a good practice to post your fee schedule so signers are aware of the legal costs before the service is performed. Question 6. A person who does not reside in New York may be appointed a notary public if a. They own property within the state of New York. b. They have a place of business or are employed within the state of New York. c. They are an attorney licensed in a neighboring state. d. They are related to a New York resident. Answer: b. They have a place of business or are employed within the state of New York. While the primary qualification for a New York notary is residency within the state, an exception is made for non-residents who have a principal place of business or are regularly employed in New York. This provision allows individuals who work in New York but live in a neighboring state like New Jersey or Connecticut to provide notarial services connected to their New York employment. If a non-resident notary ceases to have a place of business or employment in New York, they must vacate their commission. Question 7. The primary purpose of an acknowledgment is for the signer to a. Swear that the contents of the document are true. b. Declare to the notary that they indeed signed the document and it was their voluntary act. c. Receive legal advice about the document's contents. d. Attest to the authenticity of another person's signature. Answer: b. Declare to the notary that they indeed signed the document and it was their voluntary act. An acknowledgment is a formal declaration made by a person who has signed a document, stating to a notary that the signature is their own and that they executed the document willingly. The notary's role is to verify the identity of the signer and witness this declaration, not to verify the truthfulness of the document's contents. For example, when someone signs a deed, the acknowledgment confirms they are the correct person and were not forced to sign. Think of an acknowledgment as the signer owning their signature in front of the notary. Question 8. In New York, which of the following actions constitutes the unauthorized practice of law by a notary? a. Administering an oath for an affidavit. b. Choosing which type of notarial certificate to use on a document. c. Charging the statutory fee of $2 for an acknowledgment. d. Notarizing a document written in a foreign language. Answer: b. Choosing which type of notarial certificate to use on a document. A notary public who is not an attorney is strictly forbidden from engaging in the practice of law, which includes giving legal advice or making legal decisions for a signer. Selecting the appropriate notarial certificate, such as an acknowledgment versus a jurat, is considered a legal determination, as it affects the document's legal standing. The signer or the receiving agency must decide what type of notarization is needed. The notary simply performs the requested act. Remember, your role is to notarize, not to advise. Question 9. Before a newly appointed notary public can perform any notarial acts, they must take and file an oath of office with a. The Secretary of State in Albany. b. The county clerk of the county in which they reside. c. Their local police department. d. The New York State Bar Association. Answer: b. The county clerk of the county in which they reside. After being appointed by the Secretary of State, a new notary must file their official signature and an oath of office with the clerk of the county where they live. This step is mandatory to qualify and finalize the commission, and it allows the county clerk to verify the notary's signature on documents presented for authentication. Failing to file this oath means the notary is not yet authorized to perform their duties. Think of this as the final activation step for your commission at the local level. Question 10. The authority of a New York notary public extends to a. Only the county in which their commission is filed. b. Only the judicial district in which they reside. c. All boroughs of New York City, but not other counties. d. The entire state of New York. Answer: d. the entire state of New York. A notary public commissioned in New York State has statewide jurisdiction, meaning they can perform notarial acts anywhere within the geographical boundaries of the state. Although a notary's commission is filed in their county of residence, their authority is not limited to that county. For example, a notary living and commissioned in Westchester County can legally notarize a document in Buffalo, Albany, or any other location within New York. Your commission makes you a public officer for the entire state, not just your home county. Question 11. Which of the following is a key element that must be included below the notary's signature on a notarial certificate? A. The notary's residential address. B. The notary's commission expiration date. C. The signer's full name and address. D. The fee charged for the notarial act. Answer: B. The notary's commission expiration date. New York law requires that a notary public, below their signature and printed name, indicate the date their commission expires. This information is crucial for verifying that the notary was in good standing at the time of the notarization. Along with the expiration date, the notary must also include their title, Notary Public State of New York, and the county in which they are qualified. Always double-check that all required information is present to ensure the notarial certificate is complete and valid. Question 12. A protest is a notarial act specifically related to A. Certifying copies of public records. B. Witnessing the opening of a safe deposit box. C. A dishonored negotiable instrument, such as a check or promissory note. D. A sworn statement made for a court proceeding. Answer: C. A dishonored negotiable instrument, such as a check or promissory note. The power to protest negotiable instruments is a specific and less common duty of a notary public. A protest is a formal written statement by a notary, made on behalf of a holder of a bill or note, that the instrument was presented for payment or acceptance and was refused. This formal act provides legal evidence of the dishonor, which is necessary for holding the drawer and endorsers liable. While rare in modern practice, it remains one of the official powers granted to New York notaries. Question 13. Is a notary public in New York required to keep a journal or logbook of their notarial acts? A. Yes, a permanently bound journal is required by law. B. No, but it is highly recommended as a matter of best practice. C. Yes, but only for real estate transactions. D. No, record-keeping of any kind is discouraged for privacy reasons. Answer: B. No, but it is highly recommended as a matter of best practice. New York state law does not mandate that notaries maintain a journal of their official acts. However, keeping a detailed logbook is a widely recognized best practice that can protect the notary from liability by serving as a record of each transaction. A journal can provide crucial evidence if a notarization is ever questioned, documenting the date, signer's name, type of act, and method of identification. A simple rule to follow is, even though it's not required by law, a journal is your best defense. Question 14. An apostille is issued by the New York Department of State to A. Renew an expiring notary commission. B. Authenticate a notarial act for use in a foreign country that is a member of the Hague Convention. C. Certify that a notary has been removed from office for misconduct. D. Transfer a notary's commission to another state. Answer: B. Authenticate a notarial act for use in a foreign country that is a member of the Hague Convention. When a document notarized in New York needs to be used in another country, its authenticity must often be certified, and an apostille is the specific certificate used for this purpose for countries party to the Hague Convention. The apostille verifies that the notary public who signed the document is a legitimate official in good standing. For countries not part of the convention, a similar certificate of authentication is used. The key purpose of an apostille is to make a New York notarization legally recognizable on an international level. Question 15. The minimum age to be eligible for appointment as a notary public in New York is A. 16, B. 18, C. 21, D. 25. Answer: B. 18. To qualify for a notary public commission in New York, an applicant must be at least 18 years old. This is one of the fundamental eligibility requirements, along with being a citizen or legal permanent resident of the United States and residing or having a place of business in New York. This age requirement ensures that the individual appointed to this position of public trust has reached the legal age of majority. Remember 18 as the starting line for becoming a notary in New York. Question 16. A notary public cannot notarize a document under which of the following circumstances? A. The signer is blind. B. The notary is an employee of the corporation for which the document is being notarized. C. The notary is a direct party to the instrument or will receive a direct financial benefit from it. D. The document is in a foreign language that the notary does not understand. Answer: C. The notary is a direct party to the instrument or will receive a direct financial benefit from it. A notary must be an impartial witness, and this impartiality is compromised if the notary has a personal or financial stake in the transaction. For example, a notary cannot notarize a car title that lists them as the buyer or a deed for property they are purchasing. Acting as both a notary and a principal party in the same transaction is a prohibited conflict of interest that would invalidate the notarization. A good rule of thumb is, if you stand to gain something from the document, you cannot notarize it. Question 17. Which of the following is a power granted to a New York notary public? A. Performing marriage ceremonies. B. Certifying true copies of birth certificates. C. Taking depositions and affidavits. D. Issuing driver's licenses. Answer: C. Taking depositions and affidavits. The powers of a New York notary are defined by law and include administering oaths and affirmations, taking affidavits and depositions, and taking acknowledgments. A deposition is sworn testimony taken out of court, and an affidavit is a written statement confirmed by oath. Both are common legal instruments that require a notary's involvement. Notaries are explicitly forbidden from certifying copies of publicly recordable documents like birth certificates and do not have the authority to perform marriages in New York. Question 18. If a notary public legally changes their name during their term of office, they must A. Wait until their commission expires to use the new name. B. Immediately begin signing with the new name and order a new stamp. C. Notify the Secretary of State and the county clerk of the name change. D. Resign their commission and reapply under the new name. Answer: C. Notify the Secretary of State and the county clerk of the name change. When a notary's name changes legally, for instance, due to marriage or a court order, they are required to inform the Division of Licensing Services at the Department of State. The notary must provide their new signature, a copy of the court order or marriage certificate, and a small fee. After the state updates its records, the notary should also file their new signature with the county clerk, ensuring that their official signature on file matches the one they use on documents. Question 19. A key difference between an affidavit and an acknowledgment is that an affidavit A. Must be recorded with the county clerk. B. Involves the signer swearing to the truthfulness of the contents. C. Does not require the signer to be physically present. D. Can only be used for real estate transactions. Answer: B. Involves the signer swearing to the truthfulness of the contents. While both are common notarial acts, an affidavit requires a jurat, where the signer swears or affirms under penalty of perjury that the written statements in the document are true. In contrast, an acknowledgment only requires the signer to declare that they voluntarily signed the document. For an affidavit, the notary administers an oath, making the signer legally accountable for the truth of the document's content. Think of affidavit as involving a sworn oath about facts, while acknowledgment involves owning a signature. Question 20. Who is responsible for appointing and commissioning notaries public in New York State? A. The Governor. B. The State Attorney General. C. The County Clerk of each county. D. The Secretary of State. Answer: D. The Secretary of State. In New York, the Secretary of State holds the sole authority to appoint and commission notaries public. While applicants take an exam and file their oath with the county clerk, the ultimate power to grant the commission rests with the Secretary of State's office. This centralized authority ensures that uniform standards for qualification and conduct are maintained across the entire state. All official records of notary commissions are maintained by the Department of State's Division of Licensing Services. Question 21. If a document presented for notarization has blank spaces, the notary should: A. Fill in the blank spaces with "not applicable" before notarizing. B. Instruct the signer to fill in all blank spaces before the notarization is completed. C. Notarize the document as is, since the notary is not responsible for the content. D. Give the signer advice on how to correctly complete the form. Answer: B. Instruct the signer to fill in all blank spaces before the notarization is completed. A notary must not notarize a document that contains blank spaces, as this creates a significant risk for fraud. An incomplete document could be altered after the notarization by someone filling in the blanks with unauthorized information. The proper procedure is to have the signer either complete the spaces or draw a line through them before proceeding with the notarial act. This ensures the document is in its final form when the signature is notarized. Question 22. A notary public's official stamp or seal in New York. A. Is required by law and must be an embossing seal. B. Is not required by law, but the notary must print or type required information below their signature. C. Must be a rubber stamp containing the notary's commission number. D. Is only necessary for documents that will be sent out of state. Answer: B. Is not required by law, but the notary must print or type required information below their signature. Unlike many other states, New York law does not require a notary public to use a seal or a rubber stamp. However, the law does mandate that specific information be written or typed legibly beneath the notary's signature, including their name, the words "Notary Public State of New York," the county where they are qualified, and their commission expiration date. While many notaries use a stamp for convenience and clarity, it is the written information, not the stamp itself, that is legally required. Question 23. Official misconduct by a notary public can result in: A. Only a warning for the first offense. B. A civil lawsuit by the damaged party and potential criminal prosecution. C. A mandatory retraining course. D. An automatic extension of their commission term. Answer: B. A civil lawsuit by the damaged party and potential criminal prosecution. Notarial misconduct, such as acting with a conflict of interest, charging excessive fees, or failing to properly identify a signer, is a serious offense with significant consequences. A notary can be removed from office by the Secretary of State, face criminal charges, as misconduct can be a misdemeanor, and be held civilly liable for any damages caused by their improper actions. This underscores the importance of adhering strictly to notary laws and ethical standards. Your role as a public officer comes with serious legal responsibilities. Question 24. A notary is presented with a valid, government-issued photo ID, but the physical appearance of the signer does not closely match the photo. The notary should: A. Notarize the document but make a note of the discrepancy. B. Ask for a second form of photo ID. C. Refuse to notarize until the signer can provide satisfactory evidence of their identity. D. Proceed with the notarization since the ID is technically valid. Answer: C. Refuse to notarize until the signer can provide satisfactory evidence of their identity. A notary's primary duty is to positively identify the signer. If the notary has any doubt about the signer's identity, even with a valid ID, they have the right and obligation to refuse the notarization. Relying on an ID when the photo clearly does not match the person present would be a negligent act. The notary must be personally satisfied that the individual is who they claim to be, which may require asking for additional supporting identification or refusing the service altogether. Question 25. The fee for taking an acknowledgment or proof of execution for a deed or other instrument for real property is: A. $2 for each person acknowledging. B. $5 for the entire document. C. 1% of the property value. D. Set by the real estate agent involved in the transaction. Answer: A. $2 for each person acknowledging. The statutory fee for taking an acknowledgment in New York is set at $2 per person whose signature is acknowledged. This fee applies to all documents, including those related to real property like deeds and mortgages. If a deed has two signers, and the notary takes the acknowledgment of both, the total maximum fee would be $4. Notaries must adhere to this legally mandated fee schedule and cannot charge more.